but the same logic or legal rules apply to acts of the legislature in that context as would apply to you. So those tests have, by virtue of the getting this far, I think have been met as well. Did you?
Yeah, I just have a question about all this. How constitutionally were they able to override our vote? And if it's an emergency kind of hearing, define the emergency part of it. What was their emergency of for them to be able to override our vote in the legislature?
Well, all they have to do, well, in some cases it would be a strict scrutiny, you know, if they're affecting certain constitutional rights. But in this instance, what you enacted in I-148, was it? Was a statute, was a law, just like the legislature would. And in Montana, there is no special treatment for voter-enacted laws as opposed to legislatively enacted laws. They're treated the same. There is some argument that deference ought to be given to voter-approved laws. In fact, the legislature often does that. And you see it do, especially right after the vote has been...
You're speaking where it goes back to the people's vote.
No, I'm just talking, when you enacted 148, that was just a general law. It got codified in Montana, and it was as susceptible to any other law, whether it was passed by the the legislature or the people. Okay. They're treated equally.
Right. All right.
So that is. There are some states where they have a period of time where the legislature cannot touch a act of the people. And then I think that there are other states, a few, where they couldn't touch it at all, but that is not the case in Montana.
It seems to me like it's very clear in the Constitution. And I actually spoke to my lawyer, and I thought it was very interesting. He only took one class on the Constitution while he was in law school. Mm-hmm. And I was reading
I took it flunked.
Yeah, and no. if you look in the Articles of Government in Section 11 in the Bill of Rights, it actually specifically says in subsection 7 that you can challenge it on the ground of non-compliance alone, because they actually take an oath of office that is supposed to follow the organic law and the supreme power, which is actually the Constitution. So they're actually going against their oath of office, because I'm going to guess they never read the Constitution, nor do I guess they even really read their oath of office. So I understand that the referendum and the initiative is meant to challenge a constitutional bill brought about by the Senate legislature, but what is the course of action we take when they actually go against their oath of office, and the previous bill itself is unconstitutional as well? Limiting the amount of plants and the weight, that's also unconstitutional. There wouldn't even be a legislature without the preamble, and it talks about our safety, our happiness, our health, and it violates so many of our constitutional
rights. And those are all good points. Those are available legal means for you to go after.
But what is the Section 11 of the Articles of Government when it specifically says you may challenge a bill if it's non-compliant? What does that mean? That's in Articles of Government.
Exactly. And that's what I was going to say, is that, again, that's the legal challenge, not the reason why we're here to talk to the appeal. That may be a good political point to bring up to help gather signatures, and it might, when you're in a campaign, but it won't qualify it for us, and that'll be handled, I'm told, in litigation. It certainly is up to varying differences of opinion, and
but the Constitution isn't opinion. It's an organic law. There is no opinion. All laws have to be based off the organic law. There's actually MAC that actually defines law. It defines written law. It defines supreme power.
And the other thing I want to be careful of is I think this is being handled in another way, and I don't want to predispose anybody to anything that another attorney who's handling something like this might come up with theories to to advance. I
Well,
really
if they
just
only
want to
took
go
one
through
class
the
in
process.
college, I think we all could be our own attorneys
I
at
did
that
take-
point. I mean, if
Well, I
you flunked
did.
it, I mean, that's kind of, I guess I'm asking the
I
wrong person
passed,
about
I passed.
Articles Section 11, subsection 7. I mean,
I passed and I got through I got through them all. It wasn't
well, I'm just
fun,
going to not
but I
follow
did
an
it.
unjust law, because that's what Dr. Martin Luther King said. And it seems to me like there shouldn't be any ramifications to a person that wants to follow their constitutional rights.
Right.
Period. End of discussion.
So, let me get back quickly into the process so you know what would occur. You've got that. You submit the proposal, you submit the statements, you do those kinds of things. I understand somebody is going through that now and getting it. That's really a thing for. I mean, it can't be a statement that creates bias for or against the issue per se. It's got to be pretty straightforward. That's really the only rule that you need to follow. That and the words, which are 100 or maybe even be 125 now. I apologize. I should have checked that out too. But you do those statements for and against, and then you get that back to the Secretary of State. The Secretary of State sends that to the Attorney General, and the Attorney General has 30 days to make a legal sufficiency determination, some of the issues I talked about. And if he thinks that the statements don't comport with the law, the Attorney General can also rewrite the statements, and they can order that a fiscal statement be done by the budget office. They present those statements along with the petition back to the Secretary of State. Within 30 days, again, and the Secretary of State calls the sponsor of the measure and says, you know, they'll say that you've been approved, and provide a sample petition basically, or I mean the petition that's really ready to circulate. And at that point you can hit the streets. If the Attorney General were to reject for whatever reason, you would have 10 days to challenge the Attorney General's determination to that. And you would also have, if they changed your statements, you would have 10 days to challenge those. You can circulate during that period, but the caveat is that if you were successful in your legal challenge, you got them changed, all the signatures that you gathered during the legal challenge go out the window. So you really have to be careful in crafting a statement that really isn't meant to create any prejudice for or against the measure. Just be straight up about it, stick to the 100 words, stick to the 25, and then campaign and let the issues speak for themselves. Then briefly, what you should also be aware of is then in the the short time period in which you would have to circulate signatures and again get 73,000 valid, and it's based on, it's a registered elector, and they're what's called qualified electors. And if you read Article 3, Section 7 again of the Montana Constitution, see, I passed it, or at least I read it, is that a qualified elector is determined by the people who voted, the total number of votes cast in the last governor's election. So that's how they come with that, and that's why it isn't a moving target. It's not like as voter registration grows, then the burden grows, or if it if it shrinks, which it typically does not. So, or for that election, you really couldn't, with the way voter registration is now, you couldn't figure that out because people register right up to the election. So anyway, that's how you do it. That number is set. It's set as I said it was in the last, from the number reached at the last gubernatorial election. If you're going to circulate petitions in Montana, you need it to be a resident of the state. If you are paid, you can be paid on an hourly basis, but you can't be given anything of value based on the number of signatures that you collect. And no incentive pay, no bonuses, no
commission.
no free ski pass. Although some of that was tried. I've argued that it is not something that you ought to be doing. If you're popular and not under if it's not a real contentious fight, then maybe you could get away with a few of those things. But I wouldn't counsel anybody getting involved in that to go close to any of those things, especially if it's contentious, as I suspect yours will be. So I would be lily white. I would cross no lines. The last thing I would say when you circulate is the person who gathers the signature. You do that on a sheet. You can bundle sheets. There's a whole bunch of rules with that. But you need to sign an affidavit, and the affidavit has to be notarized. And you attest in the affidavit that the person who you got signature or that are on that sheet, they knew the contents of the petition that you shared with them, that you had the text of the measure with you should they want to review it, and a lot of other things. And again, you can get tripped up on all of that. So you need to coordinate. I don't know, who's going to do that, but you need a central point, a location. You need some real training, and you got to do things quickly, and you got to do them perfectly. That's what I'd say, and you got to do a lot of them. So.
Try to get 100,000 signatures to wipe out the 15% that aren't valid.
Right, and I'm no expert on that, but I know that the typical, the one I was involved in last time, I think it was quite a bit higher than, or involved in against, but they had invalidation rate that last time around, that not only for that one, but others was a little higher than had been previously, but I don't think that, I think as a general rule of thumb, if you talk to a consultant in the field, a professional signature gathering firm, which there are, they talk about 20% of your mark.
Make sure whoever's doing petitions to make sure you have registered vote cards. Make sure they fill those out in black ink.
While you're there.
Make sure, and keep them all together, turn them all in at once, please. Make sure your registered signatures are valid.
Why black ink?
That's what they say, and when I was talking to DC the other day, they said make sure it's black ink.
And another comment, when you turn these in 4 weeks before the certification deadline, so whether you're doing a ballot issue, constitutional amendment, or an initiative referendum, which this is called, the repeal, it's a 6 months total when you.
But that started a week ago.
That started April 28th.
Okay. All right. Gotcha. Cool.
Now you understand what SB423 does, right? You probably have a lot of questions on that, a lot of pissed off emotions about it. It sucks. And then you've got some understanding of how this entire thing actually works, the timelines, and what we have to do. Like, everybody in this room now, we're all a team now, everybody in this room, okay? And I'm putting my money into what John Masterson talked about, because it's worth my $200. I'll put $200 in it.
We're putting in 1,000 if you match it.
Okay, so it's really tough right now. I'll put $1,000 into it.
Thank you.
So it's your money. Don't cry. It came from the patients. It's not my money. It's coming from the patients.
So you're saying that you're backing the MCIA?
I'm going to do it because I think that $1,000 risk I think is worth it. I honestly do. Like, honestly, this 423 doesn't really impact us too much. It helps our business because we have more than one doctor and they know how to work fast. So I don't want to answer a whole lot of questions at the outset because I have a lot of material to get through. So